All right, good afternoon, everybody. Welcome to Common Scenarios Triggering False Claims Act Violations. This is the first part in a three-part series of webinars, and today's topic is government contracts and cybersecurity. I am Matt Feinberg. I'm the chair of the Litigation and Dispute Resolution Practice Group and the co-chair of the False Claims Act Practice Group at PilieroMazza. And I'm joined today by my colleague, Cy Alba, who's the practice group chair for our government contracts practice group, and Jackie Unger, who's my co-chair of our False Claims Act practice group. We're here to talk to you today about, just as the title says, common scenarios triggering False Claims Act violations with regard to government contracts. We have a little bio of the three of us, which we'll skip over quickly because we want to get to the good stuff. But before we do that, just a little disclaimer here. Nothing we say today is to be construed as legal advice. We're not actually creating a lawyer or attorney-client relationship with you through the creation or the presentation of this webinar. Your specific factual circumstances may vary greatly from the cases we talk about or the circumstances we talk about today. If you have any questions about a specific circumstance that applies to you, you should feel free to reach out to us. Our email addresses and phone numbers are on the PilieroMazza website, and we'll provide them again at the end of the presentation. All right, so just a little outline of what we're going to talk about today. First, we're going to very briefly talk about what the False Claims Act is. If you're looking for a in-depth look at the theory and the practice of the False Claims Act, you'll need to check out one of our other webinars. We want to get right to the nitty-gritty details of our topic today. We'll talk a bit about what are some common FCA violations that affect government contractors, some common cybersecurity issues that violate the FCA, and sprinkled throughout, we're going to talk about some of the hallmark or recent cases on FCA matters affecting government contractors and related to cybersecurity. So very quickly, what is the False Claims Act? It is the primary vehicle for the government to combat fraud and collect money obtained through misrepresentation or to retrieve money improperly withheld from the government. So obviously that is going to impact government contractors or really anybody who does business with the government or with government contractors. For purposes of the False Claims Act, a claim is a request for money or property going either way, from the government to the contractor or from the contractor going to the government. Pretty common example of that is going to be an invoice on a government contract. When we talk about a claim being false, what we mean is that the entitlement to that money was either improper, unlawful, or it was supported by a misrepresentation. But not all incorrect claims amount to violations of the False Claims Act. A negligent request for money or a simple mistake in following a regulation or a statutory scheme that applies to you is not necessarily a False Claims Act violation. All False Claims Act violations require a knowledge component, and that knowledge component is either actual knowledge, in other words, you knew that you were doing wrong and you did it anyway, or recklessness or deliberate indifference, which are two versions of a very similar concept, which is that you recognize that there is a risk that you are committing a False Claims Act violation or making a misrepresentation to the government, but in light of that risk, you still made the request anyway. And so that sort of gives us an umbrella of things, concepts to look at all of the cases we will talk about today. And so you want to look at them through that lens. These cases wouldn't exist if there hadn't been either some sort of knowledge or recklessness associated with the actions of the contractor. Again, very quickly, when I talk about relevant types of FCA violations, you can have a false claim or a false presentment False Claims Act violation. That means you submitted a document or a request to the government to be paid. You can have a false record or false statement FCA violation. That generally involves an otherwise accurate invoice or request for payment that is supported by a misrepresentation. And that misrepresentation could be either an express certification or implied certification. Express if it appears on the in the terms of your contract. Implied if it's an obligation that is simply implied by the fact that you're doing business with the government or by the type of work that you're doing for the government. A reverse false claim is where the contractor currently is holding money or property owed to the government and fails to return it. And there is a conspiracy to violate the FCA, which is that 2 or more people get together to commit any of the violations listed above. And generally that does require a conscious meeting of the minds and affirmative action. So let's jump right into it. We're going to go through and talk about each of these bullet points today. But generally speaking, we've broken up the common FCA issues for government contractors into about 8 general bullets. Some of them have sub-bullets, some of them are very similar in concept, but we're going to talk a little bit about improper billing, small business and set-aside fraud, performance of work issues, the Buy American and Trade Agreements Acts, non-compliant or substandard products and services, export-import issues, pandemic-related fraud, and last but not least, cybersecurity. So we're going to get started with some improper billing. Jackie, I'm going to kick it off with you. Could you go over a little bit about how government contractors can run into improper billing scenarios that might trigger an FCA violation?
Sure, thanks, Matt. Yeah, so improper billing is probably the most common, and it can cover the most straightforward situations that we see, and also more complicated situations as well, as we'll see from some of the examples that I'll talk about in a minute with the settlements that we've seen. But, you know, and we have some different scenarios listed here, and improper billing can cover, you know, just incorrect invoicing. So is the invoice that you submit, is there something wrong on there in terms of like the rate of the personnel that you're charging or the number of hours that they've worked? Are you actually making sure that what you're charging for is the right thing in terms of the product that you've supplied, you know? So just making sure that on the face of the invoice itself, that it's actually accurate in terms of what you're supposed to be billing under the contract. And that all of the amounts are right so that you don't end up overbilling or double billing the government. It's also, you know, we see scenarios where there's improper hidden markups or profits that shouldn't be charged either because you're dealing with cost reimbursable CLINs or where it's not, you know, you should be identifying to the government what the profit is and you're adding profit into other line items where it's not supposed to be charged. Under the different legal theory that Matt just touched on, false certification could arise when you're dealing with billing despite failure to meet contractual or legal requirements. So that's not necessarily something that on the face of the invoice that you're submitting, there's not something in terms of the charges there that's false, but by submitting the invoice itself, you're certifying that you're in compliance with your contractual or legal requirements. And that certification can either be made expressly via a statement on the invoice that says, I certify that the company is meeting all requirements, when it's actually not. There could be a false certification, or just if you're not in compliance with those requirements and by submitting the invoice, you are representing that you're in compliance. So an omission from telling the agency where you're not in compliance can be counted as a false representation. So it's important to understand those different scenarios of, you know, overbilling or not providing the service that is represented in the invoice itself versus the fact that not meeting all of the requirements in your contract could provide a base, but yet submitting an invoice for the work could lead to FCA liability if there's a knowledge element there and that non-compliance is material to the government. There can also be liability for billing for unallowable or unpaid costs in the subcontract chain. So you need to make sure, again, if you are seeking recovery for costs incurred, that those costs have actually been incurred and paid out, and that the costs that you're billing for are allowable under cost principles. And similarly, we see liability where the contractor incorrectly identifies or allocates its indirect costs appropriately to its contracts. So if we go to the next slide.
Well, Jackie, before we jump to the next slide, I wanted to point out something that you just mentioned. So you're talking about unallowable or unpaid costs in the subcontract chain. On a prior webinar you and I did, we had talked about some scenarios where the subcontractor's false claims travel all the way up the chain to the prime contractor. And so if, maybe you want to talk a little bit about how prime contractors should take a look at their subcontractors' invoices to make sure they're compliant before passing that invoice or those charges on to the government to be paid on the prime contract.
Yeah, that's right, Matt. And I think you hit the nail on the head there that that liability can travel up. So you need to be paying attention to your subs invoices and not, as Matt alluded to earlier, burying your head in the sand, which can be deliberate indifference. If there's something there that you should be aware of or paying attention to from what your subcontractors are billing and how they're handling their costs and their invoices. You can't just ignore any red flags that you see. Make sure that you're following what the requirements are for your prime contract and flowing those down to your subcontractors and doing your due diligence of what they provide to you to make sure that it's appropriate for you to pass on those charges to the government. And as you don't, because it's not just actual knowledge, but also reckless disregard or deliberate indifference where you could be found liable under the FCA. So here we have listed some recent settlements that relate to improper billing. I'm not going to talk about all of these, but I do want to talk about a few of them. So the first one here is a $377 million settlement, which is one of the larger procurement fraud settlements that DOJ has recovered. This related to, the settlement was to resolve allegations that the contractor improperly billed indirect costs to the government. The government had alleged that the contractor improperly allocated to its government contracts indirect costs that were associated with non-government commercial and international contracts that either had no relationship to the government contracts or that were allocated to those contracts in disproportionate amounts. So the contractor allegedly obtained reimbursement from the United States for costs of non-governmental activities that provided no benefit to the United States. So this is a relatively rare example of an FCA settlement that's based on alleged violations of the cost accounting standards. But it was just such a large amount, and it dealt with the settlement resolved a key TAM suit that was brought by a former employee. So the issues had been raised within the company, but not reasonably dealt with and investigated, leading to the practice continuing that led to this issue. So this is a situation where we're talking about incorrectly identifying or allocating those indirect costs leading to False Claims Act liability. The next one I want to talk about is the $70 million settlement to resolve allegations that a contractor utilized improper cost plus percentage of cost subcontract, which isn't allowable. So in this situation, which was resolved just recently, the defendants were both wholly owned subsidiaries of the same parent company. And the defendant prime contractor entered into a contract with the Navy to provide logistics and maintenance on aircraft. And the prime identified particular parts and products. The contract basically didn't allow for any markup on the actual cost of replacement parts under the contract. So no profit was allowed on that. And the prime ended up entering into a subcontract with a company that was the other subsidiary or another subsidiary of the same parent company to provide the parts as a vendor. But under that subcontract, the sub would mark up the parts by 32% of whatever the cost was, making it end up being a cost plus percentage of cost subcontract. And the prime went ahead and billed that to the government for the total quote from the sub, including the markup, which wasn't allowable. So in this situation, there was a benefit within the same family of companies, and there's like there was more of the actual knowledge side of the wrongdoing and nefarious activity here. But it goes back to the point we were just talking about of the need to make sure that you're paying attention to your subcontractors and what they're billing as well. Going down to there is an $18.4 million settlement to resolve allegations that the contractor billed the US government for work not performed. This related to the contractor's submission of invoices that included timesheet hours that were not actually performed. So this relates to just incorrect invoicing on the face of the invoice. The contractor was billing for hours that were not actually worked. So on the face of the invoice, it was incorrect. And that's where the falsity came from. And then the last settlement here relates to the contractor billing the government when it failed to meet contractual manufacturing specifications. Basically, it was required to perform monthly testing, which had not actually been done. So this is a scenario that relates to the false certification. By submitting the invoice, the contractor is representing that it's in compliance with all of the contract specifications, including that testing requirement, when that had not actually been done. So there's a false representation there.
So before we jump to the next topic, we have a question from the audience, and I'm going to throw it over to Cy in a second, but the question is signing a certificate of current cost or pricing data, can that lead to liability for FCA issues where the costs are later redetermined? So Cy, what do you think about that one?
Yeah, so if you look at FAR 15406-2, it talks about what you're supposed to be basing your determination on. And so it's current cost and pricing data, and it's supposed to be based on information at a particular point in time that you negotiate with the contracting officer. So if you say, we're basing it on everything on like August 1st, 2024, or July 1st, 2024. And then 10 days, 20 days, 30 days, whatever later, you're going through some audit or you're looking at things and you find out it wasn't right. However, a reasonable business person, given all the information that your company had, not you personally, but the company had, would have made a determination to agree that as of that date, the company had no information to show that it was wrong, then you should be okay. However, if the company had information that showed that certain things might not have been accurate or might not have been correct, then that could be considered recklessness, that you didn't pay attention to that or try to dig into it or clarify the situation at the time. So that could lead to an FCA issue based on recklessness, even though it wasn't knowing, as opposed to if there wasn't any information that you had at your disposal. In that case, then the certification would have been accurate as of the time. So it depends on the facts and circumstances and whether or not the company had any information that could have led you to believe that it was inaccurate.
One thing to think about is that definition of claim, and to have a false claim, there has to be some sort of request or withholding of money from the government. So if there is a misrepresentation in your certificate of current cost or pricing data, and it leads to the submission of an invoice which has an improper amount, and it's not later corrected, that's sort of the overarching example of where you might find some FCA liability is making a request for money from the government that in some way was unjustified. But thanks, that's a great question. So I'm going to skip ahead to small business and set aside fraud, because this is a real hot button issue over the last 3 or 4 years for the Department of Justice. And they are focusing very heavily on fraud in the small business and SBA set aside programs. Cy, can you tell us a little bit about what's been going on and what small business fraud might look like?
Sure. So I think something for people to understand right out of the gate before we get into the specifics here, is that unlike many other false claim scenarios like overbilling or other things we're going to get into later, the government doesn't necessarily look at what its calculable damages are when it's determining the penalties, right? When you're dealing with small business certifications, there's something called the deemed certification rule, right? Where if you submit a bid for a small business project, you're deemed to have willfully certified that you are small, which gets you over that FCA hump that we were talking about, that it has to be knowing or it has to be with reckless disregard. There's sort of a presumption that it was knowing, essentially. And in addition to that, the damages portions of it is also presumed under the presumed loss rule. And the damages are presumed to be 3 times the value of the contract. So the gross value of the contract multiplied by 3. And then every invoice that you've submitted, or in theory, there was some other claim that was submitted, that you actually submitted an REA or something under that contract for some amount, then the penalties are roughly $25,000 around there per invoice or per claim, in addition to the 3 times the value of the contract. So if you're looking at these small business issues and the damages that can arise, they are greater as a percentage of value than any other damages that generally occur. And that's based on Congress making a judgment that as a matter of public policy, they wanted that to be the case. And that's why these things are arguably more important than any other area, because if you're found to have had bad concrete or something, then the question is, what are the damages? And it could be 3 times those damages. It's not going to be the entire contract. But with small business certifications, it can be the entire contract. At least that's the theoretical damages. So with that being said, there are different types of small business fraud issues that the DOJ has been focused on. There's situations where the prime contractor is not eligible. It's a large business, or there's some affiliation that they should have known about. You've got situations where there's a fake small business. It's just a figurehead. A lot of times in the serviceable vet context, this is referred to as rent-a-vet. It's also something that is fairly, I think, widespread, unfortunately, in other circumstances like woman-owned small businesses. I've seen a lot of situations where there's fraud there, where you've got this figurehead person that's a veteran, that's an 8A owner, that's a woman, whatever, those categories of companies. But that individual, the person upon whom eligibility is based, is not actually running the company. Instead, it's someone else behind the scenes that is not an eligible individual. That is a specific situation where you would have fake figurehead companies. Failure to meet ownership or control or employee-based requirements. So ownership or control, kind of similar to the fake or figurehead scenario, except instead of being this like obvious thing where you've fronted someone that's not even involved, let's say, you can have it where it's a little bit more nuanced. So you've got your corporate documents, your governing documents, meaning your operating agreement if you're an LLC, your bylaws or shareholders agreement if you are a corporation. In those documents, you have problematic issues. You have it so that the non-qualified individual can control different things, can veto different things. And that's where you also get into these nuances of, well, was it knowing, or was it reckless, or was it negligence, or is it so bad? Is there some sort of dispute, right? Is there a legal question about whether or not the provisions in a particular agreement rise to the level so there is improper negative control, meaning control by a minority owner? And those things can be nuanced, because to rise to the level of a false claim, or even beyond that to something that's a criminal matter, that has to be pretty bad, right? It has to be something where you knew that these things didn't qualify, or you were reckless and it went sort of beyond the pale. If there's some legal argument that it's appropriate, or potentially there's a new case that's never been found before, so say control over initiation of litigation, right? That was a case where last year the Office of Hearings and Appeals said, if you are controlling initiation of litigation, that's improper negative control. that was never found before ever in the history of any case, that's probably not something that's going to rise to the level of a false claim. And in fact, in that particular instance, it was then overruled by the Court of Federal Claims, so it's not even improper. Those are sort of examples, or an example of a situation where you're probably not rising to the level of a false claim. But be aware that that can be a potentially problematic issue. Then generally affiliation writ large, right? You can have affiliation due to familial identity of interest. You can have affiliation due to common investments. If a bunch of people all have a bunch of companies and you're all common owners in a bunch of companies, and you're like, okay, we're going to try to avoid affiliation because Bob, you're going to be the 51% owner over there, and Sue, you're going to be the 51% owner over here, and blah, 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 blah. But you're all tied together and everybody's investments are all looped into everyone else, right? That can cause affiliation amongst all the companies, even though you've attempted to set it up so you've got 51% over here, 51% over there, and you're trying to make it so that there is no affiliation. SBA could still find it because of something like that. They also then, the last affiliation standard is always totality of the circumstances. Now, personally, I have an issue with the idea that someone ever can be found liable under the False Claims Act based on a totality of the circumstances test. I just think it's too vague. How could you knowingly or with reckless disregard for the truth violate a totality of the circumstances test? I just think it's BS. I'm not sure it's possible. Now, I'm not aware of a case that has actually taken it all the way through, because the reality is when you're going after small businesses, they don't have the financial wherewithal to take a case all the way through trial and then potentially onto an appeal scenario to make that determination. And between us, I think that the DOJ knows that, and they can be bullies sometimes. So be aware of that as well. So if you're working along the periphery or you're trying to be creative or in certain scenarios, there is risk attached to that. And there are things you can do that I think you would have reasonable arguments. But if you're even in the situation where you have to make an argument on these issues, it can be problematic. And if you're small, you might have already lost just in reality, because it's going to cost so much to actually overcome these things.
Yeah, I mean, Sai, you may have given everybody on the line a little bit of heart palpitation when you were talking about the organizing documents for an organization. I mean, I think the emphasis that we want to put on is there can be mistakes in an organizing document. They're unintentional. If you didn't realize what you were saying is what ended up creating an FCA violation. Obviously, you want to get those fixed, but I can foresee and have seen cases in the past where two business partners come together in two very different industries or with two very different workplace experiences, and they're going to work together to create a new government contractor. And to meet the obligations of a set-aside program, someone has 51% and someone has 49%, but they're truly 50-50 partners. I think that's the point. You need to be looking at the requirements of your set-aside programs, thinking about how that will implicate your working relationship and what that truly means for whether you can be 50-50 partners, or if someone really needs to take the reins and lead the company with another person as an advisor, but someone's got to make the call. So, I mean, I think that's a really good point. Why don't you give us some examples of the recent small business cases, because there have been some big ones.
Yeah, so this first one here, the 48.5 million, that's one of the largest false claims settlements. Again, a lot of these, even if the numbers are really high of 300 million in potential damages, they usually get negotiated way down. Well, this is an example where the actual settlement was extremely high. I mean, from the perspective of small companies, for sure. And this involved allegations that a large business used a small business contractor as a pass-through entity to gain access to small business set-aside contracts. And there you're talking with a situation where a company is sort of a puppet master, right? If you have a situation where you really know what you're doing, and especially if you know what you're doing and you're trying to structure the corporate documents, which is what Matt was just talking about, the governing documents, you're structuring them to on paper meet the rules, but everything in the background is that you're really controlling everything. You're setting up all these business relationships as sort of fronts. That's where you can really get into trouble, because not only does that show you're not following the rules, but it shows you like intended to do it. And especially think about all the emails you send every day. When push comes to shove with these kinds of questions, that's where the rubber meets the road. They're going to get access to emails, and if it doesn't come from you, if you're like purging everything, which do not do that, if you're purging all your stuff all the time, the other guy might have emails, or some server somewhere in Office 365, whoever, might have records of things. And if the government gets a hold of all these emails where you're just like, no, don't worry about it. You don't have to do anything. I'm just going to cut you a check. We're going to do all the work. You just need to get 51% of the profits, and you just need to be in control of the company. That type of reasoning or thought process is setting yourself up for fraud, right? And serious problems. Other settlements like this one for 1.75 million was allegations that a company was acquired and they continued to self-certify. Now, there are some situations where you could set up acquisitions so that you don't trip the control rules, and maybe someone's taking a minority interest and the control is still residing with the other party. And if you have reasonable arguments, then you probably don't have to worry about this, or at least if this does come up, you can have arguments to push back on it. But if someone acquires you 100%, they own you, they control you, there are very specific rules about what that means. You have to recertify in your current contracts. You might, depending on the terms of the contract, not be able to bid additional task orders, but you might be able to, right? The agency just can't take credit. You have to recertify. There are certain steps you need to take. And if you fail to take those steps, even though you should have, the law is pretty clear on what you're supposed to be doing. And if you didn't do it, it's going to be treated as reckless, that you didn't even look up the rules, you didn't even attempt to comply. And that's where you run into False Claims Act for situations like that. This other one, 750,000-ish, right? That's a settlement regarding allegations that a contractor and its CAO set up alter ego companies, right, to allow these guys to keep getting 8A contracts even after they graduated. That's something that I'm not sure how uncommon it is, but this is a particularly egregious scenario. SPA even tells people when you graduate, go find the 8A companies that are capable of doing the follow-on and go team with them. Go form joint ventures with them. Go be a mentor protege with them in joint venture and go after certain work with them to keep that pipeline so you can keep some portion of the work. That's all legal. But if you're going and setting up a company, right, to work with them only like in name, right, and you're really going to be a front and you're doing all the work, that can land you in serious trouble. And lastly,
and so, well, but on that $742,000 example, I think there, degrees of severity to everything. And I think I'm familiar with this case, and essentially what the original prime contractor that had graduated from the 8A program was doing was he was reaching out to 8As and essentially taking over the company. Like the CEO of that company no longer existed. They were literally a figurehead, and the CEO actually was running their finances. The CEO of the graduate A was running their finances, was making the call on which contracts to bid on, was executing the contracts on behalf of the companies, was picking the subcontractors. Essentially, the CEO of these new 8As had no control over the company. And so, I mean, I think that's where we talk about these egregious examples, the ones that are there's no gray area. That's pretty black and white. He had taken control of these other companies and was basically farming out the work to the company that had graduated. And it was designed to perpetuate what the incumbent had kept on the prior contract. But go ahead, sorry to interrupt.
I have had one though that I think is kind of BS too, where the Department of Justice said, look, you had this mentor-protege relationship. You were a great mentor. We're not denying that. On every contract you did after the first two, you were great. You helped them out. You did all the work. Now they're a thriving business. Congratulations. You were a great mentor. But on the first two, you were doing too much. You were writing the proposals for them. You were submitting the proposals, and the government, or the protege didn't even realize that it was going in as a joint venture, going in as a prime sub relationship, because you flipped at the last minute, they didn't even know. Some of that I think I have some issues with, because I think it's a pretty common practice that the first time someone's doing something, they're not involved, they're watching you, right? So if you're writing a proposal and you're saying, here's an amazing proposal, that's on the line, but I want people to be aware that even if you're in a mentor-protege relationship, it's not a get out of jail free card. There, you can still be found affiliated and still be found to have improper control over your protege if you're doing things outside the scope of the agreement or you're going too far. So that's sort of a tweak on that, and just be careful with that as well. And then lastly, this $36 million one, you've got a scenario where the CEO was creating all these other things. He was really, this one company, he was really in control of all these other different companies. And when you have that kind of situation where you have a bunch of companies that are truly controlled by the same individual, or in another circumstance, I had someone who they were really in control of things, or allegedly in control of things, because they were a contractor, but they were in a role serving as like the president of the companies, even though they were a 1099 to all of them. But in reality, if you look behind the curtain, they were in control. And when then the government, the FBI, and the Department of Justice interviewed the employees and said, well, who's really in control? Who do you report to? Everyone kept pointing to this contractor. That's another kind of circumstance where you can run into issues, and you should know that just because somebody isn't the actual CEO or isn't the actual president, or if they're just a consultant but acting in that role, you can still run into problems. And certainly if someone is the CEO of multiple companies and you're just ignoring the affiliation, that's even a bigger problem, especially if you're not, like in this case, you're not the service-able vet, but you're really controlling everything. Or even if you are a service-able vet, and you've got 30 service-able vet companies and they're all affiliated and you're ignoring it, it can be a problem.
So we have another good question from the audience, basically asking if the owner of an 8A company, an 8A company that's been certified by the SBA, no longer meets the compensation limits for the 8A program, but continues to certify as an 8A, could this result in a false claims or fraud determination? So like any good lawyer, I'm gonna say it depends. It really depends on the nitty-gritty details, because there are things to consider, like, is it an IDIQ contract or a multiple award contract that was issued while the 8A company was not only certified, but also the CEO, or the owner rather, met the compensation requirements? That company can continue to bid on task orders under the IDIQ until you get to the point of recertification. On the other hand, there are instances where the SBA understands, it is disclosed to the SBA that the owner has exceeded the income requirements, compensation limits, and the SBA does not remove or early graduate the 8A company. If that's the case, then no, because the government is aware of the situation. Where you might run into problems is if the owner knows that they are or is reckless in determining their compensation limits and continues to certify to the SBA that they are an eligible 8A representative, or if there's some concealment or some moving of property or assets in order to try and stay under the compensation or asset thresholds. So, I mean, without giving you a straight answer, the answer is always going to be, it depends really on the nitty-gritty details of the circumstances. But in theory, yes, an 8A owner who exceeds the compensation limits could lead their company into an FCA violation, depending on certain circumstances and depending on the specific facts.
I would say too, remember when you're calculating that, it's kind of what people take out of the company. So if the company's making $4 million in profits and I'm the 100% owner and I'm 8A, if I'm leaving the money in the company, then it's generally not considered under the actual income test. So don't get confused with that either.
Right. But there are other factors that go into 8A eligibility, and any number of things could trigger a loss of 8A certification. And the reality is that DOJ, if there's a whistleblower who reports it or DOJ finds out about it, they're not going to give you the benefit of the doubt. They're not going to assume that you're acting in good faith in trying to calculate whether you're still eligible to certify your 8A company. So the take-home lesson here is be vigilant of the numbers, make sure you're paying attention to your compliance requirements, and ask questions when you need to, including of lawyers, but also of your BOS, to ensure that the government, the SBA in this case, knows what's going on and can give you advice about whether you're an eligible 8A or not. And if they're going to graduate you, you've still got that off ramp during the graduation, the pre-graduation period, where you could sort of tidy things up and potentially have the SBA relook at early graduation. So something pretty similar to small business fraud, at least in part, is performance of work issues that come up related to contracts. Jackie, can you tackle this one for us?
Sure. So Cy and Matt were both talking about really the small business eligibility at the front end of getting that contract award in the first place. Is the business, does it qualify as a small business, woman-owned small business, SDB, OSB, whatever is required at that front end stage? Performance of work, we're turning to looking at, okay, now during contract performance, what are the requirements there? And is the small business meeting those requirements during performance? So with the limitations on subcontracting, there's the set percentage of work under SBA's regulations that the small business prime contractor needs to perform on any set aside contract, which is different depending on whether you're dealing with a contract for services where they have to perform at least 50% of the work versus 15% for construction, you know, so there you have to be aware of what the different percentages are. And so if there's a situation where the prime contractor, small business, is not complying and is passing through too much work to its subcontractors who are not similarly situated, meaning that they're not a small business on a small business set aside, or they don't have the same socioeconomic designation for a WOSB, SDB-OSB, hub zone set aside, that they're not exactly the same designation as required for the prime contract, and they are passing through more than is allowed under limitations on subcontracting, that could be a basis for FCA liability. Again, the scienter element is relevant there, but the the prime contractor needs to be tracking its own performance and the amount of work that it's passing through to its subcontractors. The main concern here is just making sure that the prime, the small business prime, is not acting as a sham or a pass-through entity where a large or otherwise ineligible business ends up doing the majority of the work and getting that payment, when the whole goal of small business program and the set-asides is to make sure that the small business is the one that's doing the work and getting the benefit from that. And so similarly, there are performance of work requirements within small business joint ventures, whether they're mentor-protege joint ventures or not. When the joint venture is being used for a set-aside, the small business managing partner of that joint venture needs to be performing at least 40% of the joint venture's work. So it's super important for small businesses to stay abreast of the requirements for joint ventures, for mentor-protege joint ventures, if they're going down the mentor-protege route where they want to work with a large business, and understanding the limitations on subcontracting rules, not just the percentage of what can be subcontracted, but how it's actually calculated. So what goes into that? Now the rules for that have been clarified or revised over the past years to make it easier for small businesses to track that calculation, since it's just based on the amount that the government pays to the prime contractor and the amount that the prime contractor actually pays out to its subcontractors. So it's a little bit easier to track now than it was under prior versions of the rule. But it's very important for small businesses to understand what those requirements are, as we were just talking about, whether it's eligibility requirements in the first place, or what they need to be doing during contract performance. Okay, so a couple of examples here. I will just say, at a high level, there have been a number of settlements where there is this pass-through situation where the small, large businesses are basically taking advantage of small businesses, or the small business who's eligible to get the contract ends up passing through too much of that work, and they're just being used for their designation as a small business to get the contract, and then having the large business or otherwise ineligible small business do the majority of the work. So I do want to point out that the issue of performance of work does not necessarily only apply to the small business set-aside world. In this third example here, there is a settlement in a case that related to claims from the government in the amount of $37 million that alleged that the prime contractor subcontracted 70% of the work on the contract when the contract limited them to only subcontracting 40%. So this wasn't a matter of the small business regulations, the limitations on subcontracting under SBA's regulations, but just given the circumstances of the prime contract, the government in that scenario wanted the prime contractor to be independently capable of performing the majority of the requirements here. And so you have to pay attention to your contract terms. You can't just say, okay, I'm up to date on SBA's requirements, so I'm good to go there. Actually read what the contract says to make sure that there could be separate limitations there as well about what your requirements are. So, you need to read through the whole contract.
Yeah, that's a great point, Jackie. I mean, the contract controls, the regulations that might affect a contract are usually incorporated by reference, but if there's a specific contract requirement, you might be giving an express certification or at least an implied certification with every single invoice you submit to the government. So when you're awarded a contract, the advice I always give is read that thing front to back and highlight the actual requirements that you're responsible for, so that and implement a system of checks and balances to make sure that you're complying on an invoice by invoice basis. So we're going to stay with Jackie and talk a little bit about the Buy American Act and the Trade Agreements Act. Jackie, take it away.
Yeah, so I could talk about BAA and TAA requirements all day. There's a lot here. There's a lot to it. They're very complex, but I'll try to talk about this really quickly. Basically, the government has a lot of domestic sourcing preferences through the BAA. There's a preference for US-made products. Under the TAA, contractors can also provide products from certain designated countries if the products have been substantially transformed there. And so generally, the contractor, the important thing to recognize is that the government, there are circumstances where the government can still end up purchasing products that are not from the US when BAA applies, or not from designated countries when TAA applies, under certain exceptions. But the key obligation, so you can still provide or offer to provide products from non-compliant countries, but you have to tell the government when you're providing products from those countries. You have to let the government know in your proposal up front, so that the government can make a determination of whether an exception applies and whether there should be a waiver of BAA or TAA. And so there's a specific process, a certificate for BAA and TAA, where the contractor makes its representations about whether the product is from a foreign country or not. And I want to point out that it's basically a representation by omission. So if you do not identify that your products are from a foreign country, then you are representing that the products will be from a domestic end product made in the US if BAA applies to your contract. Or if TAA applies, you're representing that the products will be from the US or a designated country, unless you specifically take the affirmative step of identifying which products are coming from a different foreign end country and which country is the country of origin. So it's kind of like it's very easy for contractors to get caught up and not recognize that they're making these misrepresentations just by omitting to say anything. So there, with BA and TAA, you know, because of the way that the representations work, even where you don't affirmatively say anything, you can get caught up in FCA liability with that. There are defenses with BA and TAA. There could be circumstances where compliance is not necessarily material to the government's decision to pay for the products. Sometimes they just identify a specific product that they want. They know they want that product. They don't care where it comes from. That's the one that they want. They're going to end up getting it regardless of where it comes from. So the fact that that product may not come from a compliant country doesn't, you know, change things at the end of the day. Or the government might be willing to work to get a waiver for the contractor. So a couple examples here. You know, there's a $2 million settlement to resolve allegations that the contractor failed to comply with BA and TAA when selling textiles to DoD. In that situation, the contractor marketed its products as made in America, and they actually took the step of replacing foreign manufacturers' tags with tags that read made in America. So, you know, that's pretty blatant in terms of the knowledge element, that they had actual knowledge that their products were not made in America, and they were trying to hide that from the government. There's also this $625,000 settlement where the contractor failed to comply with BAA when selling scientific instruments to federal agencies, where the actual origin of the products was from China. In this circumstance, you know, there could be a little lower settlement because it could be that circumstance where the contractor, you know, maybe didn't really understand its BAA obligations and the representations that it was making in its contract when it didn't fill out its certificate appropriately, for instance. But that could still lead to reckless disregard by not understanding what the contract required. So again, very important to actually read through all the contract terms, including the FAR clauses that are incorporated by reference, to understand what they require and how those are, you know, whether you're compliant with them and what representations you may be making by what you disclose or don't disclose in your proposal.
All right, so we like to talk about the FCA, and we have talked a little more than we should have in the time so far. So we're going to start speeding through. Cy, can you tackle some non-compliant or substandard products or services issues for us?
Yeah, so this is not another example of things where you've got a situation. I know everybody's heard of like different concrete issues, right? You get certain substandard concrete that's made with junk, and the building is at risk of falling apart. Like that's kind of a quintessential example where the government's looking to acquire something and it doesn't meet the requirements. Now, you have to sort of know, right? It's the same thing, knowing or reckless disregard for the truth. So you're getting a bunch of substandard concrete from China, you're not even checking, you're not even testing, you're selling it, that's a problem. If you've got a scenario where I had a client that had beacons that were emergency beacons that went on life vests, you would eject from your airplane, go in the water would activate the beacon. Unfortunately, the glue was bad. And when the beacon hit the water, it leaked, it would break the beacon. So instead of the water making it go off, the water actually broke it. That's a problem. However, those guys were not in trouble with a false claim because that was just a situation where the glue, there was a bad batch and it caused a problem. That's not a false claim. In some of these other circumstances, like some of the settlements we have on the other page, they falsified testing. So if that client would have sat there and said, I'm going to test the glue, oh crap, this glue is bad, shh, don't tell anyone, sell it to the government. That's a false claim as opposed to just defective manufacturing, okay? That's where you're running into, in these types of cases, the big difference. The one thing I'll note with this sort of disturbing trend section that we had on the list is I'm starting to see DOJ make claims where there's what I think are contract disputes and they're turning it into FCA cases. So for instance, if you're selling something to the government, some service, and it's a fixed price, and it says, do this every month, and it says unit number 12, unit type monthly, that pretty clearly, you bill every month, it's firm fixed price. What if it says unit each or unit like 12 and it says each in the same contract where it says unit 12 month? We've got circumstances where DOJ is taking that and saying 12 each and 12 month are not the same thing. You should have known that, even though it has 12 and even though it's a firm fixed price contract. So you were falsifying your invoices by billing us the same thing every month. That seems to me like that's a contract dispute question, not a false claim question, but I'm pointing it out because we've started to see DOJ in certain regions grasp at those issues. And so just, again, read your contract, like Jackie said, very carefully and understand what you're looking at and what the distinctions could be so you don't run into these kinds of problems.
All right, so we've also got issues with export and import fraud. Jackie, can you help us out with that one?
Yeah, so a couple ways that we see FCA liability with respect to this is if the contractor misidentifies the country of origin of the products to avoid import taxes or fees. And it could also misidentify products to avoid those fees. So it's either, misidentification of the country of origin or the product. Both ways can lead to getting around those fees. So as examples of this, there is this roughly $23 million settlement to resolve allegations that the contractor misclassified these products. Imports of raw ingredients and bulk vitamins as duty-free when they were actually subject to substantial customs duties. And then the second one here it involved a judgment of $25 million where the importer identified butt weld pipe fittings as steel couplings. So they're changing the product identification, which allowed them to avoid $8 million in anti-dumping duties. Although they actually did identify those products as butt weld pipe fittings and marketing materials, which can go to the knowledge element there. That one's currently on appeal.
All right, it's something we've been talking about for 4 years and probably won't stop for another 4, pandemic-related fraud. Cy, what can you tell me about PPP loans and other government-funded bailouts?
Yeah, so here, I think the big takeaway here is that it really goes back to the original application, and a lot of this are companies that are falsifying records and they knew what they were doing, okay? They're creating sham companies, they're listing their family members as employees, they're clearly affiliated with major large companies, no question, yet they're still submitting. Those kinds of situations are where we've really seen False Claim Act liability. We haven't really seen False Claim Act issues if you're like on the periphery, or some people say, well, if you're a government contractor, you should have never applied. That kind of stuff, we have never seen any issues like that. And I don't think we're going to. I think with these kind of situations, what you're really looking at are people who are falsifying records. And in those cases, they're getting hit with these kinds of settlements, right? Where they've created a group of companies, they're inflating their payroll figures by putting family members on the payroll where they weren't actually employees at the time, they're just falsifying it. Allegations that they're self-certifying they're a small business when they're clearly not a small business because they've got a bunch of other companies with a bunch of family members, things of that nature. That's really where you've got people that are having issues, or I can see where people are falsifying records to show for the second round, to show a loss when there wasn't really a loss there, knowing or doing it on purpose, essentially.
Yeah, and Cy, that's a good point. I've attended a couple of conferences where DOJ attorneys have spoken about their pandemic fraud efforts, and they really have to date focused on the really bad actors, the ones who are, knowing that they were not allowed to apply for a PPP loan if they were in bankruptcy, changed the name that they were applying under, or adjusted, didn't disclose the bankruptcy, or maybe they applied and received funds twice under the same cycle and then requested forgiveness of both loans. Candidly, the DOJ doesn't seem to be going after the mistakes where people received 2 loans in one cycle, but they didn't request forgiveness because they recognized it was they were ineligible, but where they're seeking forgiveness of 2 loans in one cycle, I have seen that happen. So let's get to topic number 2 of the day. We're going to go a little bit over. We're sorry about that, but we're going to try and cover as much of this as possible. We're going to talk about cybersecurity fraud. Cy, why don't we talk about this a little bit?
Yeah, so when you're dealing with some of the cybersecurity issues, this is also becoming a hot button and probably going to increase, right? Once these things like CMMC really start to take off, you're probably going to see this happen more and more. If you know that you're not meeting the requirements, or you should have known, right? You recklessly disregarded the truth. That's where we're also seeing folks have issues with these cybersecurity questions. So, for instance, if you know you weren't meeting the NIST 800-171 standards, and you are certifying that you are meeting the standards, and in cases where that has caused the government to violate its requirements under 853, we've really seen the government drop the hammer on people, because now it's not just an issue where you're not meeting it and that was a violation of the contract, they would have never awarded it to you, so there's all the damages there. But in addition, they now aren't meeting their own requirements, and how many people were impacted by that? Because they're relying on the contractor to meet the government's requirements, and now there's risk of leaks. In particular, you're seeing these things come up where there is a breach. If there's a breach and now they're looking into it and they realize this breach occurred and it could have been preventable, now you're really looking at, it was material, it was clearly material, there was a breach, there are serious damages, and now I'm going to hold you responsible for it because you weren't meeting the requirements you promised to meet. In addition, like this artificial intelligence thing, I think is interesting because it's really future looking. You see SOUP 6 requiring companies to specify if they're using AI in their proposal writing. What if you lie? What if they awarded to you and you didn't specify appropriately that you were using AI? Maybe there's policies that the government doesn't want people to be using artificial intelligence, or they want to take a closer look at that. What if the AI is creating awesome language? Like, that sounds great, and it's completely BS. Or what if you're fudging things more than you otherwise would because the AI is scouring your website and claiming things that you did by mapping it with other companies' websites that have similar language, but you're not really doing that. Though these can be things that you're putting it, and if the government relies upon it and awards you work and now you're getting paid for it, these are the things that could become problems down the line, especially if, like with SOUP, they're making you identify when you're using it.
So if I could actually jump back to 2018, which was the actual first time that we saw a settlement or judgment in a cybersecurity FCA case, the situation there was that the contractor was alleged to violate both NIST 800-171 and NIST 800-53. NIST 800-171 applies to the contractor. Anyone who understands or is required to meet these cybersecurity requirements probably understands what 800-171 is. 800-53 at the time was the government's requirement for cybersecurity policy and or cybersecurity in general. And so what the allegation was in that case was not only did the contractor fail to meet their own cybersecurity requirements, but it performed its contract in a manner that prevented the government from meeting the government's obligations for cybersecurity. And this is a little bit in that false certification, implied certification, or express and implied certification that Jackie talked about earlier. It was an implied certification, or at least the allegation, the complaint was that by entering into this contract, the contractor was impliedly certifying that it was capable of performing in a way that would allow the government to meet its obligations. That was never going to show up in an invoice or a proposal or a solicitation, but that is what was read into the case for purposes of that case, at least. And it was a settlement, so it didn't, again, like Cy said, didn't go to verdict, didn't go to a judgment, it did not go to an appeal. So we don't know if that's necessarily how the court would apply it, but the implications of cybersecurity stretch beyond whatever the cybersecurity requirements of your specific contract are. But there are some more examples, including this $11.3 million settlement that is just a couple of weeks old. Sai, you want to run through some of these, and then we'll very quickly wrap up for you with a little discussion about DOJ's focus on cybersecurity.
Yeah. So, for instance, this latest one, you've got a situation in New York, right, where they were supposed to be giving these rental assistance programs, and as part of what they were doing, they had to have these cybersecurity requirements. And as a portion of the contract, they were relying on a third party to provide cloud services. And the reality is that they weren't meeting the proper requirements, which could cause a lot of leakage, spillage, and various problems, right? And that's where this is becoming more and more important with various, security threats, but also privacy issues. And a lot of individuals can be put at risk very quickly. It's not the same kind of thing where you had paper files. People have to take the paper files out of some warehouse, get them into a truck. It's really hard. Nowadays, you can have the entire Library of Congress stolen in a matter of minutes, and God knows what is going on with that. So that's why you have to realize how important these things are, and that's why these damages can be so large. Or things like allegations that the contractor failed to provide these trusted internet connections to the government they were relying on. Who knows who would have scraped that information as data was flowing from place to place because it wasn't secure. And sometimes it's very hard to tell what's going on. So these kinds of risks are exactly what we're talking about and why these are so huge. People see these sort of breaches happening all the time with Target and everyone else and just kind of shrug, right? Because it's like, well, there's my private information gone again. We'll see what happens.
Yeah, time to change my passwords.
Right. But the government doesn't have that luxury. And if you're working for the government, you can't just shrug it off either.
Particularly if you're in the healthcare space and you're transmitting patient information or housing patient information, if you're providing medical services in the public or private sector, because keep in mind, if you're offering healthcare services, you may be receiving Medicare or Medicaid dollars, in which case you might be required to comply with your Medicaid and Medicaid privacy requirements. If you're transmitting personal identifying information, maybe you're working for, the Department of the Treasury or the SBA and transmitting personal identifying information of eligible companies or loan recipients or anything like that, or you're storing it, you need to make sure that you're meeting these cybersecurity requirements, because this is one of those instances where if you're not meeting your cybersecurity requirements, the government could come say, you aren't entitled to a single dollar on this contract because at no time are you meeting the cybersecurity requirements that were the fundamental purpose of this contract. And so your $10 million contract with the Department of Treasury or the IRS is now essentially a False Claims Act violation that they're going to seek $30 million in recovery for. So let's wrap up. Jackie, can you tell us a little bit about DOJ's specific focus on cyber fraud, and then we'll sign off for the day.
Yeah, thanks, Matt. So the point here is just, we've covered cyber fraud, how that can lead to FCA liability. We just wanted to point out that DOJ has created this civil cyber fraud initiative that started back in October of 2021, which just highlights what an important area the cyber fraud and compliance with these cybersecurity requirements is to DOJ. They're investing a lot of resources into this initiative to investigate where there might be FCA liability here. Just shows that this is a really growing area of interest to DOJ. The intent of the initiative is not to create any new cybersecurity requirements, but it is to use the FCA to enforce current requirements and deter non-compliance. So under the initiative, the areas that DOJ is focused on is where the contractor knowingly provides deficient cybersecurity products or services, misrepresents their cybersecurity practices or protocols, or violates obligations to monitor and report cybersecurity incidents and breaches. There's a couple settlements here, but they relate, again, going back to the false certifications of compliance. So, representing compliance with the cybersecurity requirements in the contract when they actually have failed to, meet those requirements and protect the information, which was critical to the contract requirements. As Matt said, it's not surprising that a lot of the focus in this area goes to the healthcare industry because there are such stringent requirements for protecting patient privacy. The overarching takeaway here is that cyber FCA risks are growing for all contractors that are subject to increasing cybersecurity requirements, including what Cy was just highlighting, CMMC requirements, and also there have been a lot of new and evolving demanding agency requirements for providing quick notices of breaches, and that reporting those incidents and breaches is one of the areas that the initiative is focused on as well. So just another reminder of the importance of paying attention to your contract requirements as it relates to the cybersecurity requirements in there, including reporting any breaches of them and the timing for doing that. It's not just what the contract requires, but whether you're, as the contractor, acting at a minimum recklessly disregarding what those requirements are and whether you're in compliance with them or not. And if you recklessly disregard whether you're in compliance and yet you submit the claim to the government under those contracts where those requirements are, then there is that basis for FCA liability.
Great, thanks, Jackie. Thank you, Cy. The Olympics are coming up, everybody. We sprinted through that last 20 minutes or so. I'm sure some of you have questions. You all sent questions to us, but we didn't get to them. We will reach out where we can. If you have any questions for any of us about any of the topics we talked about today or anything else that you think affects government contractors, our contact information is up here on the screen. You can also get our direct dial numbers on the PilieroMazza website, which is PilieroMazza.com. I hope you all will join me tomorrow when I'm joined by my colleagues Jessica Du-Hoffman and Sarah Nash to talk about FCA in the construction industry. And then we'll wrap things up with a third installment with my colleague Mark Rosenow when we talk about solutions for how to handle FCA investigations and litigation once they come up. Feel free to reach out if you have any questions. We've enjoyed talking to you today, and we'll see you soon in the next couple of installments. Thanks, everybody.